What binds a judge today to a decision made decades ago? What invisible chain of legal authority compels courts across Nigeria to follow rulings they did not themselves deliver? The answer lies in one of the most foundational doctrines of our jurisprudence: case law, or judicial precedent. Stay with us. Case law, also called judicial precedent, is that body of law which is built up through the authoritative and binding decisions of courts, otherwise known as precedents. In all countries and at all times, decisions of courts made in the course of litigation are treated with respect, and they tend to be treated as precedents which subsequent courts will follow when called upon to determine issues of a similar nature. It is critical to note that case law is often referred to as judge-made law. However, this designation must not be misconstrued to suggest that judges are legislators or that the court is synonymous with the legislature. Rather, judge-made law is a phrase deployed to indicate that it is the rule of principle as laid down by the judge in the process of judicial administration that is binding. The question then arises, what precisely within a judgment is binding? The answer is the ratio decidendi of the case. The ratio decidendi, that is, the reason for the decision which is authoritative and binding. An obiter dictum, a statement made by the way, not essential to the decision, may be persuasive, but is never binding. This distinction was judicially affirmed by the Supreme Court of Nigeria in Dalhatu and Turaki, where the apex court drew a clear and deliberate line between ratio decidendi and obiter dictum, emphasizing the binding force of the former upon subordinate courts and parties alike. The legal doctrine that gives judicial precedent its commanding force is stare decisis, a Latin maxim meaning stand by decisions of past cases. This is the bedrock upon which the common law system, to which Nigeria subscribes, is erected. As affirmed in Nigerian Army and Philip Abiyomi, Nigeria is a common law country, and the foundation upon which the common law system is erected is the doctrine of judicial precedent. A precedent, in common law legal systems, is a principle or rule established in a previous case that is either binding or persuasive for a court or other tribunal when deciding subsequent cases involving similar issues or facts. The doctrine enjoins that all courts are bound to follow decisions made by courts above them in the hierarchy of the judicature, and appellate courts are normally bound by their own past decisions. Its primary purpose is to ensure uniformity, fairness, and certainty in the application of the law. Beyond uniformity, stare decisis serves as a form of judicial restraint, preventing judges in lower courts from issuing decisions that are out of line with what higher courts have determined as established law. In a judgment, there are several elements: findings of material facts, statements of the principles of law, and the decision of the judge. These three elements, the facts, the applicable law, and the decision, together constitute the ratio of the case. Only this ratio carries binding precedential authority. A judge does not exercise arbitrary discretion when making decisions. Rather, the judge rests his judgment upon general principles enshrined in case law as a whole, reasoned judgments based upon rational principles. Case law, therefore, does not consist of a blind series of decisions, but of principled adjudication grounded in legal reason. A significant jurisprudential challenge arises when a lower court is confronted with conflicting decisions of a higher court. What option is then available to the lower court? This question was directly addressed in Nweko and Governor of Rivers State, where the Court of Appeal per Kalawol, JCA, observed that when a higher court could change its position, there would be undue uncertainty in the law, and that if each doubtful question were allowed to be re-argued, different divisions of the Court of Appeal might pick and choose which of conflicting decisions to prefer. The majority view, which draws its strength from a long line of authorities, holds that the lower court may pick or choose between the conflicting decisions. However, the minority view, now increasingly ascendant following the Supreme Court's pronouncement in Cyril O. Osakwe and Federal College of Education, Technical, Asaba, holds that lower courts are bound to follow the latest of the conflicting decisions. In Osakwe and FCE, technical, Asaba, the Supreme Court made it abundantly clear that in line with the principle of stare decisis and strict recognition of its supremacy, a court confronted with conflicting decisions of the Supreme Court must follow the decision that is later in time. This pronouncement substantially restricts the earlier freedom of choice afforded to lower courts. A further exception to the binding force of precedent arises where a decision is made per incuriam, that is, in ignorance or forgetfulness of a relevant prior decision or statutory provision. As judicially pronounced in Nweko and Governor of Rivers State, whenever a relevant prior decision is not cited before the court or mentioned in the judgment, it must be assumed that the court acted in ignorance or forgetfulness of it. If the new decision thereby conflicts with the prior established decision, it is rendered per incuriam and is not binding upon a later court. Furthermore, in Dalhatu and Turaki, the Supreme Court rebuked a trial judge who had refused to follow an earlier Supreme Court decision, having erroneously characterized it as per incuriam. The apex court made clear that lower courts cannot, upon their own initiative, dismiss binding precedent on such grounds without proper foundation. The practical operation of judicial precedent in Nigeria is vividly illustrated across several landmark authorities. In Asimo and Abraham, the Court of Appeal was confronted with conflicting decisions of the Supreme Court on the jurisdiction of the High Court over customary right of occupancy matters. The court navigated these authorities by applying the principle that, where decisions irreconcilably conflict, it is the later decision that binds. Similarly, in Enugwu and Okifi, the Court of Appeal per Alagunju, JCA, delivered a sharply worded rebuke against a High Court appellate judge who refused to follow the Court of Appeal's earlier decision in Chikalu and Ifemejulike, a decision subsequently vindicated by the Supreme Court in Oyeniran and Egbetala. The court characterized such conduct as insufferably arrogant and running against the canon of judicial ethics. In Adagoke Motors Limited and Adesanya, the Supreme Court itself grappled with whether the decisions in Skinkonsult and Yuki and Izomo and Oyakire were truly in conflict. The apex court, exercising its inherent jurisdiction, resolved the matter affirming that an erroneous decision of the Supreme Court upon a question of law can only be set right either by the Supreme Court itself or by statute. The doctrine of judicial precedent remains the cornerstone of legal certainty and judicial integrity in Nigeria's common law jurisprudence. Its twin pillars, the binding Ratio Decidendi and the persuasive Obiter Dictum, operate together to ensure that the law is applied with consistency, predictability, and fairness across all tiers of the judicature. As legal practitioners, law students, and informed citizens, it is imperative to appreciate that the courts do not adjudicate arbitrarily. Every decision is anchored in a chain of authoritative pronouncements stretching back through decades of judicial reasoning. Stare decisis is not merely a procedural rule, it is the very architecture of justice under the Nigerian legal system. If you found this exposition instructive, kindly subscribe to this channel, engage with this content through your comments and questions, and share it with fellow law students and legal enthusiasts. Justice, after all, is best served when knowledge is widely disseminated. This has been a legal educational production. All materials cited are sourced from authoritative Nigerian law reports.